want to talk to you today about a fact situation where you're facing a second DUI charge. In other words, you've got a prior criminal record, you pled guilty or were found guilty of impaired driving a few years back. Will you face a jail term in this situation? The criminal code states that for a second time DUI, you're facing a mandatory minimum penalty of 30 days in jail. So depending on the nature of your case, if it's a more minor impaired charge you're facing, you're going to go to jail. There's no question about that. However, there are some situations where if it's an old record, say for example, over 10 years old, just as an example, the Crown could exercise their discretion not to impose a jail term so that they don't rely on notice of the prior record. The judge in this situation then, based on a joint submission, could give you a fine. The Crown, for example, might do that with a very old record, or if they perceive you've got a potentially winning case, so there are going to be some negotiations with the Crown. However, in situations where the prior record occurred, say within 5 years, the Crown has no discretion. They have directives and policies in the province that they have to rely on the past record. When the record's past 5 years, it's going to depend on the county and the Crown as to whether they rely on that record and give you a 30-day jail term or more. For example, it's very high readings. A judge could give you longer than 30 days in jail. So that's the short answer to whether you're facing a jail term on a second-time DUI.